How does the California landlord handle a tenant's abandoned vehicle on their residential property? Hi, my name is Rob Wells. I'm the Landlord Warrior on TikTok and YouTube. Please feel free to like, share, and subscribe to our videos. Now, we've been running into this lately, and it is a frequent occurrence where a tenant is either evicted from a property or they move out pursuant to a termination notice, that type of deal, or in the middle of an eviction. And what they do is they leave an abandoned vehicle on the property. And California Vehicle Code section 22658 prescribes the remedies for how a landlord can handle that, including a common interest development, aka an HOA. Basically, if you leave, a vehicle like in a condominium complex, that type of deal. So for my mom and pop landlords, if you're renting out single family homes, this vehicle code section specifically allows you to have a vehicle towed and impounded pretty much without any type of notice. Okay, that's going to be vehicle code section 22658 subdivision A 4. Basically, the prerequisite is you just have to have a parcel with a single family dwelling. Okay, so not my multifamily folks, that type of deal, that doesn't count for you. Okay, if it's an inoperable vehicle, the vehicle code does prescribe that you got to contact your local law enforcement agency, and I think you have to give them at least 24 hours notice that you're going to have the vehicle towed. Okay, and inoperable means it doesn't have an engine or substantial item, so it's operable safely on public roadway, that type of deal. So that's usually handles the single family homes deal. If you are in a multifamily property and apartment complex, that type of deal, usually bigger complexes like that usually will have a sign as required under vehicle code section 22658 subdivision A1. It has to be 17 by 22 inches, and it tells you, hey, if you park in an authorized way, manner, that type of deal, you're subject to tow. If you have one of those signs per the vehicle code, you could have the vehicle towed. The other way around that is if you don't have signage at all the entries of the parking lot, that type of deal as described, you have to issue a written parking violation and provide 96 hours notice that the vehicle will be towed. And generally, if when in doubt, just do the 96-hour notice thing. So all you have to do is basically write a note saying, hey, you're unauthorized parked at the property. Basically, we're going to tow the car 96 hours per the vehicle code. Many tow companies, from my experience, they charge a fee to the landlord, but generally speaking, per the vehicle code, the car has to be impounded in a proper, impound lot, that type of deal. And if the car is, has a current registered owner, that type of deal, like plates and so forth, the tow company gets a lien on the vehicle for any storage, that type of deal. So tow companies, generally the ones that you have to hire are ones that can actually impound a vehicle, and they usually have contracts with the city or local municipality, that type of deal. They pretty much know how to handle this. But if you're in lawful possession of property, which you would be as a landlord once you complete an eviction or your tenant surrenders property, you can use the vehicle code to basically have a vehicle removed from property. And from time to time, I do have landlords that have to exercise that. So if you're facing a landlord situation in the Northern California area and you need help, feel free to reach out. We might be able to help you out. Put your comments, questions down below. Until next time, folks, I'll talk to you then. Thanks.